All right, before the next speaker comes up, I just wanted to go over a couple of information pieces that were in your folders. I don't know if any of you have ever had any interactions with our local senior centers, but that is a really great resource for caregivers and care recipients alike. There have been a few adjustments to the eligibility for meals at the local senior centers. And at this time, I mean, it's been crazy, obviously, with COVID, and, you know, they did open a lot of the centers back up, but it's at a limited capacity. So there's a flyer that it says senior centers on it, and it has a list of the locations where you'll find a senior center in the 7 counties that we serve. I think we have 36 centers. But I wanted to go over eligibility for a meal at the center because that is something that has been updated. If you are a client that is over 60, you can attend the center and have a meal. If you are the spouse of someone over 60, you are also eligible to attend even if you're not 60. That's something new. But the only catch is that the person over 60 has to be there also. Like, you can't just go without the person that is 60 or older. Okay? But that's a new addition. And then also a person with a disability living with someone over the age of 60. That does not have an age requirement on it. So, like, you might have a grandparent that is over the age of 60 caring for a grandchild at home, a disabled child. They can both go to the center and get a meal. Okay? So for specifics on if your local senior center is providing meals or, you know, has the room to serve you at this time, just give them a call. You can find the numbers in the senior resource directory that we put on the tables for you, or you can Google it. I mean, it's just so many different options or you can call us and we'll point you to that, you know, to that center that's nearest you. Let's see. And I think it's time for our next speaker, so I'm going to go ahead and hand over the mic. Oh, door prizes. I'm sorry. Door prize.
All right. Speaker, she is from TroyBank and Trust, and she will be speaking on some points about estate planning, documents you need to have, and certain accounts that caregivers should be aware of in your role as a caregiver. Take it away, Tenise.
Okay, thank you.
And we do have a handout. We'll be handing out something while she's speaking.
Well, thank you for letting me be here today. I'm excited. As Tenise Owens, I've been with TroyBank and Trust in Troy at the main office for 23 years. I have been in the trust department. I have been a caregiver for trust clients in my early 20s when I started there. So I know what you guys are going through. I'm also a caregiver for my mother. So what the trust department, what we do real quick is that we take care of a lot of individuals, the elderly that does not have family present, does not have family that wants to fool with it, to be honest with you, doesn't have family at all. So TroyBank serves as their power of attorney. We're on call, I'm on call 24/7, and a lot of people don't realize that a bank does this. But a lot of times, if we're the only person in that customer's life, if it's time to go to the hospital, I get up and go to the hospital with them. I'm having to make decisions. I'm having to plan their funerals. I have planned more funerals and I'm 45 years old that I can imagine. But also we have a service where we provide sitters for our customers. So of course I do not serve as a sitter. I'm just the one that's kind of legally responsible and financially. So we do sitters around the clock for our clients. We do the hiring, the firing, the scheduling. We do all the quarterly reporting, the W-2s that are issued at the end of the year. So right now we probably have maybe 3 customers that we're running 24/7 caregivers, and at one time we could have had a maximum of 7. And that is a job. I don't know your role if you're having to have sitters for your family member, but that's a job. I mean, it is a major job and stressful. We've had to go at Thanksgiving because a sitter didn't show up, one of my assistants, until we could get another caregiver in. So A lot of people just don't know that trust departments do that. Not many trust departments do that. We've been in existence since the early 1900s. TroyBank was formed in 1906, the trust department in the 1930s. And so that's kind of why we've had our long history of our departments, because we will do those personal things. So what I have, your handouts, I want to talk a little bit, and I think another speaker this afternoon is going to talk a little bit about some of this, but I want this to be real informal. So I want, if you hear something, to immediately stop me, let's ask a question. We will have question and answers at the end, but let's don't wait. If something you hear and you want to throw a scenario, I hope I'll have the answer for you. If not, I can always get your information and contact you back. But what you're looking here is just the key estate planning documents. Before I start, let's show of hands, are you a caregiver currently serving for a possible spouse? If you raise your hand. Are you a caregiver serving for a child, a disabled child? Are you a caregiver for parents? Okay. And did anybody that serves a different role than what I kind of threw out, or?
Just a friend.
Just a friend? Okay, all right. So I'm going to try to touch on some facts that you personally need in your life, and then also you need for, if you're the responsible party for your family member or friend, you need to have this knowledge so you can share with them to make sure that they have their financial matters in order. Now, to do any of these, they have to be competent enough to sign any kind of document. So if they're past that, they're kind of limited to what they can do. But power of attorney. Now this is a situation where we see it get messed up all the time. All right, there's a couple of different types of power of attorneys. One is a durable power of attorney. That's what we see a lot at the bank. What that means is that when the customer signs it, it's endorsed, it's witnessed, it's notarized, it becomes in effect immediately. So that person in a durable power of attorney gives whoever they named, gives them full financial power, as if that person was standing in the bank doing it themselves. Such as, if I named you as my power of attorney, you could go to TroyBank and Trust, close all my accounts, and the bank would have to honor it. You could take my name off my account and put your name on my accounts. So you can go borrow money in my name through the power of attorney. You can sell real estate. So whoever that person is named, you need to make sure you can trust them 100% that they would do the right thing for you. Now, there's something called a springing power of attorney, and that is where, the power of attorney does not go into effect until some attorneys write it to doctors, including your physician, have to say you're incompetent. Okay? So it does not go into effect until that power of attorney has two statements by two physicians, one being your own, saying that you're incompetent and cannot handle your affairs. If you do not have some sort of power of attorney, there could be a means that you have to go to the probate court and get declared incompetent. And that's a process that nobody really wants to go through. When you can do a power of attorney, attorneys do not charge very much for power of attorneys, and that avoids all that. So really think about it, that whoever you name, you need to trust. If you name one person, go ahead and name a backup in case something happens to that person or that person could not serve for whatever the reason might be. A lot of times, if we're in TroyBank sends the estate plan for the customer, they might name their spouse as the primary power of attorney, and then they name TroyBank and Trust as second. And so what that means is when we're called to serve, then we can go and collect assets, open up an agency kind of account, and do bill paying. We can call. When we do bill paying for our clients, AT&T won't even talk to us unless we show them a power of attorney to pay their bill. So, the power of attorney comes into handy. Has anybody dealt with power of attorneys? Have y'all had any horrible situations or?
I have a possible upcoming situation.
Okay. Do you want to talk about it or?
My husband's in the nursing home presently, been there since December, and he wants to come home, of course, but he's not going to be able to for a couple of reasons. But now he wants to go live with his son.
Okay.
Of course, he tells me, all you've got to do is sign me out of the nursing home, I can go live with him. So I'm wondering, how much would it cost if they decided that they would overrule me, and, I mean, would it cost a lot of money? What would the process be if they decided they want to take him to live with them?
That's the son?
Yes.
Okay, power of attorneys usually just address the financial aspects, so that would, now, you're talking more like a guardian. Is your husband incompetent where he cannot manage his affairs? So, probably that case, and I'm not an attorney, that they would probably want to fight and be named his guardian versus you. The power of attorney, again, is only probably going to address the financial impacts of your husband. So it's really two different things. TroyBank and Trust does not like to be involved as someone's guardian because they're going to be making a lot of healthcare decisions, and I do not want to be in the role whether this person needs a feeding tube and so forth. So they could petition through the court system maybe to be appointed as a guardian.
So it would involve a lawyer, and it probably
it will be a long process, yes, ma'am.
It would be costly for them?
They would have to, if they petition as the guardian, they might could get reimbursed out of the funds, your husband's funds,
Yeah.
but they would have to upfront probably all the cost, and if they were named as guardian, there could be a possible, recovery from his assets. But again, that's something you probably want to go ahead and talk to an attorney before it's, hits you right in the face and they try to do that. I'm going to tell you a sad situation is that we had a 80-something-year-old lady, and she gave her granddaughter a power of attorney. And then she started, we were paying her bills, and she was starting to receive collection notices. And she was getting to lawsuits where the attorney, the granddaughter went to Ward's Yamaha in Troy, bought a couple of four-wheelers in grandmama's name with the power of attorney, very legal, and of course she didn't make any payments and so forth. Grandma does not want to press charges against granddaughter. And so what happens is that she's having to either file bankruptcy, try to do some repayment plans, get a loan, pay them off. So, and something an 80-year-old woman does not need to go through with such a limited budget that she was on. So, again, you need it, it's important. If you're caring for somebody, they're going to ask you for that. If your family member has an account at TroyBank and Trust, any bank, and it's just in their name, they're not going to should not give you any access to that account, shouldn't give you balances, couldn't give you any money, unless one, you have a power of attorney that is valid, or two, you have to go to the court system, a conservatorship has to be established, you have to prove that person's incompetent. There's a guardianship and a conservatorship. A guardianship is over the person, so the conservatorship is over the person's assets. You got two attorneys involved, you got court costs, you have publication costs, all that kind of stuff. It's just not the route to go when you can do a 6-page power of attorney, whatever it is, to take care of future issues. Any questions on a power of attorney? Now let me tell you something else we're starting to see, and it's gone wrong. I gave you my power of attorney, right? So you go into my TroyBank and Trust account, and you come sit down with a personal banker, and you say, I am Tenise Owens' power of attorney. I want to be put on her account. You have every right to do that. Like I said, you could close my account and move all that money into your name, and the bank cannot question the bank. If it's a valid POA, then you have to do it. What's happening is you don't have to be on my account. You just have to give the bank, the financial institution, a copy of the power of attorney. They're going to let you have access, information, write checks off the account as you choose. Now, if you are on my account, you are now a joint owner. So if I die, my will doesn't come into play, my estate doesn't come into play, you automatically, the bank's just going to give you that money, okay? So, well, what's wrong with that? Well, if there's 3 other siblings, that might not be exactly what mom wanted, okay? But the bank has to give the money because you got yourself as a joint owner. So now you have potentially put yourself in a situation where your siblings, other family members, could have a fit because you abused, they could say, the power of attorney. That was not mom's intent. So that is a big mistake we're seeing because what happens, oh, she's going to do the right thing, she's going to split the money. Well, I said, she dies 2 days later after me because she grieved herself to death. So what's to happen now? That money, which is mine, that should go to all my children, she gets it, she dies 2 days later, it's now her estate. So her new husband could potentially be the beneficiary of those funds if he decides not to do the right thing, and the bank cannot do anything about it. So do you see how that could get really messed up? So be the power of attorney, have it done legitimate, and then just don't go put your names on the accounts. But they're doing it every day. And if the bank, if that's your request, we do it. We hope to, they should be educating you of what you're doing and what can happen when mom dies, but it's still whatever you direct the bank to do. And I'm just picking on you. I'm sorry.
That's okay. That's all right. Now, this is good information. Thank you.
Yes, ma'am?
Troy Bank and Trust. If I was to open an account with the bank that you employed with, and I wanted to add someone to that account, what is the requirement?
So you have an account, an existing account, and you come to the bank and say, hey, I want to put Tenise on my account.
Yes.
Then they will redo, you could keep your account, and they would redo a signature card and make it a joint account and not just a single party account, how it was before you came or called. So that would mean they would transfer it from a single party account to a multiple party account, redo the signature, make you sign, and make the new person sign as well.
What would be the requirement for the other person?
You can put me, I can come by, we can go to TroyBank, and you put me on your account after this. There's no requirement. I mean, you can put anybody you want to on your account. They will have to sign.
They will need to sign.
They'll sign the signature
Will
card.
they need to provide ID?
And now I'm not on the bank side, I'm in the trust department. So I'm sure what we always do is do a driver's license, social security, provide address, that so forth.
Thank you.
You're welcome. But, yes ma'am.
I just want to piggyback on that comment. They don't do any, if the bank, what if this was an elderly person? And, maybe they got memory loss or something. They don't do any type of investigation if they know some of the person's family.
That's a big privacy issue. Now, if they're at the personal banker's desk and they're drooling at the mouth, kind of it's very obvious they're not here, we would probably, and I cannot speak for the bank side, but I would think we would question it and possibly get our legal team involved to see how they would advise us going forward. But that's reaching. You've got all these policy and privacy issue rules that, because I could see a checking account and I could see that there's some crazy things going on in mom's checking account. I don't know how far a banker has to investigate, and then who are they supposed to? Do they call the son? Well, it's mom's account, so we have just violated some privacy issues kind of thing. But I think the next college that they're going to have, we're going to have our compliance officer come, and she's going to talk to you guys about elderly abuse, because we're seeing a lot of it. Yeah. We're seeing people, a lot of lottery scams, sending in $10. I had one lady, she died at 103. She was a client of ours since she was age 60, so she was like my grandmother. I didn't have her when she was 60, but once I started at the bank. But she was as tight, and she was mean, and she would not give anybody $1. Well, she started slipping a little bit, and she got wrapped up in, you send me $10, you're going to be in the lottery winning for $5 million. She bought into that. It was a battle. We ended up having to use a power of attorney to, she would have her mind, but then she did not have her mind. She had some of her issue, but she swears she thought she was going to win $1 million. And she just sent 5. Has anybody had any of that happen to their family members?
I work for DHR, and we go through a lot of scams with elderly people that are thousands of dollars in the hole because of it.
And a lot of times it's family members.
Well, and also like those foreign scams. Facebook Messenger is the devil for elderly because they fall into it.
They'll call. We have one issue where they'll call and say, this is TroyBank and Trust. Someone will call just a log of people and try to say they're from the bank. Something's wrong with your account. Can you give me your account number and let me check into it a little bit more for you? that's never gonna happen. Like the IRS is never gonna call you on the phone and asking for your social security number. Not gonna happen. But people do it, they give it, and then they start after later thinking, I don't think I was supposed to, and then they call the bank, then we have to freeze the accounts, close that account, open a new account. It's happening a lot.
One thing that I've seen a lot is these people will send a check to the elderly people, say deposit this check, and then take this money and go help these people in need, and then therefore they're taking this fake check, depositing it, and somehow the bank is letting it go through, and then they're withdrawing the money that's not really there. So then they're accountable for replacing the money.
Right. And I mean, it's really sad, but that 103, she was on everybody's list, and they started calling her on the phone, and she gave out her account information, I know, twice, and we had to jump through hoops. But there was an individual that was going to come to her assisted living, had met a time to bring her a check. So of course we had the police, notified. No one ever showed up, but it's sad how they prey on the ones that need help the most. Yes, ma'am.
I was just going to say, my mother-in-law suffered from dementia and Alzheimer's, and we almost waited too late to get a power of attorney. So I just wanted to say, don't wait.
No, ma'am.
And everyone in this room should have a power of attorney. With someone that you trust right now, because you don't know what tomorrow holds.
Absolutely.
And tomorrow could be too late.
And the thing about it is a power of attorney document dies with you. So when you die, that document is no longer valid. So you're just done with it. You're going to have to go through that court process to be appointed a guardianship and a conservatorship, as you know, if you're a DHR. It's not worth it. It's so many cost and stuff and expense, and it's just a sad situation. Yes, ma'am.
In Alabama, does a durable power of attorney have to be notarized and recorded and all that stuff?
Does not have to be recorded. I think the only time it has to be recorded, do not hold on me, I'm not a lawyer, I just play one on TV right in front of you guys. I was kind of nervous because they told me right when I got here I was being recorded. So anyway, so it has to be notarized. We recently had a situation where there was a power of attorney. The lady was was on hospice. She did have her mind. This is not my customers, but a bank customer, and they did not have it notarized. They just had 2 witnesses, and one witness was actually a family member. So I think the bank decided that was not a valid POA because it was not notarized, but I don't know that exactly. Okay, but every power of attorney that I am under, TroyBank, is always notarized. Now, of course, you have to be confident enough to be able to sign. But did that kind of answer your question?
Notarized and 2 witnesses?
No, I think no, it's just notarized. Notarized. The will, a self-proving will in Alabama requires a notary, 2 witnesses, and the notary has to notarize the witnesses and the grantor of the will. He has to notarize all 3 to be a self-proving will. So that might be where you're getting the witnesses.
Okay, because we'll go over self-proving wills.
We will if we have time.
Okay.
Did you have a question?
So how does the bank verify that it's a good document?
Our staff is supposed to be able, they can't, if someone just handed a banker a document, they're supposed to read it. Because sometimes in the title of the document, a lot of attorneys do durable power of attorney. Some do screening power of attorney. Our front-end staff has to know and has to be able to read that, determine, does this only go into effect if there's 2 letters attached to it from 2 physicians saying you're incompetent? So we are trying to educate our front-end staff, because those are the ones. A lot of times they'll call me, send it to me, and I tell them what they can do and cannot do. But you can't just go on a title, you've actually got to read it. Now, you do record a power of attorney, usually if you're selling real estate using through it for title purposes. So if you're trying to sell mom's house, you're a power of attorney handling that transaction. The closing attorney for a title opinion, a good, clean title opinion, is going to record the power of attorney because it's going to want to know why you're signing the deed. Okay? So that's usually, now some people get it recorded just to get it recorded, but It's not required, because I operate, all mine are not recorded unless I have to sell real estate. Somebody can change their mind. So if mom's competent, you do a horrible job, and she wants to name son now, she can revoke that power of attorney. She is required, or she's supposed to send a letter to whoever she names saying that this power of attorney has been revoked on a certain date. Please return the power of attorney to me. And that's her notice notifying that. Then she needs to go to all her bank, her financial institution, her brokerage accounts to let them know that she's made a change. Because if she doesn't do that, Wells Fargo, that has the brokerage account, does not know. So they're still going to let the daughter's power of attorney be the active one and do. So if you're going to do it, you've got to follow the whole process. Ma'am, do you have a question or?
I'll wait.
Okay. Okay.
We had our durable power of attorney and will and everything drawn up in Florida. Do I need to see an attorney here in Alabama now that we're residents?
I cannot speak on state of Florida laws. So, like I said, a power of attorney is to me, for what it provides, is very inexpensive. So it might be a good idea now that you actually are residents of Troy, Alabama, just do a new one. But
Okay.
if you have an attorney here, just call and see what they advise. But if you're not planning on ever going back to Florida, just do you a new, because I don't know if the rules are different.
Well, the problem being is the time we did it in Florida, my husband had not been diagnosed technically with dementia. Now he's been diagnosed with Lewy body dementia. And his thought processes are not there.
Can he understand if an attorney was sitting in front of him, could he understand what he was doing and what he was wanting to do at that moment in time?
I would not say 100% no.
Okay. Well, do not tear up the Florida power of attorney.
Hand it in.
So, but you probably should go ahead and, because now you can't name your husband, so you got to think who your agent's going to be.
Right.
And if it is, like I said, make sure you name, if you name an individual, make sure you name a backup, because that individual could die or that individual could not serve for whatever reason, or not want to serve. You know, you're putting yourself liable and having to account to other family members, other siblings of what you might be doing with the funds. Okay? Very important.
On power of attorney, does the bank have a separate, like Merrill Lynch, I'm going through this right now. Merrill Lynch has a separate power of attorney than, like I've got an attorney that did a power of attorney.
I don't know why they do that.
And Merrill Lynch is one place that has a separate one.
Right.
You have to go in there and sign theirs with, like my instance with my father. So I've got a power of attorney with Merrill Lynch and a power of attorney with an attorney.
And say, I don't know why. I had another brokerage firm that had a fight about that, because what if by the time you need that at the brokerage, he's already incompetent, he cannot sign their power of attorney? Why would the power of attorney not work that is legally done by an attorney?
Yep.
But some brokerage houses are definitely different.
So when you said Wells Fargo, that type of deal, I want to know, some places do have, your power of attorney is no good with them, like Merrill Lynch is no good.
Exactly, and some people might say, I'm not going to accept this power of attorney until it's recorded.
Right.
Some places, because I guess there's just been so much abuse on power of attorneys that they're really having to do some extra work there. I mean extra criteria, but it's just, I think that's silly. But I've had some issues with ours where they didn't want to take it and so forth. And I've never had to record one yet, but I've had to get my attorney involved, the bank's attorney, to try to handle the situation. But does that help? Is that confusing? Did y'all already know that? I wasted y'all's time. Okay. But I'm serious about the account, being on the account. That's not what you have to do if you are a power of attorney. Okay? Because you can have access to all the funds. If you go put yourself on a joint owner and everybody is doing this, then you now could create a problem. If your mom and you have two other brothers and you're going to do the right thing and give it to them, but guess what? The bank's going to give the money to you. We're not going to give it to anybody else. So just know that could happen.
But at least get your name on the account, or get somebody's name on there, because if something happens, you lose the account, correct or no?
If your mom has, or your father has an account that's just in his name, nobody's name on it, you have power of attorney so you can pay bills, he dies, then the bank is gonna look for the executor of his will to come into the bank.
What if there's no will though?
Well, the state of Alabama has a will for you. So that's why it's important that you do a will. That's not very expensive if it's a simple will, but that names an executor. That's the person in charge of the estate. A person dies, if he has assets, or she, just in her name, then they're going to be looking as the executor that's been legally appointed by the probate court to come in and collect those assets. And then you would follow what the will says. But if you die without a will, state of Alabama has a will for you, and it's not called probating a will, it's called petitioning for administration. Because this guy died without a will and he had assets. He didn't have any beneficiary paid on death. That's another way you can do it. So the court's going to appoint somebody, make them get bonded, which is another expense and so forth. Somebody's going to be named as an administrator, and then they can go collect the assets. But you can always do paid on death on any accounts. So instead of, if you're worried about, I don't need to be on mom's account, but we don't want to have to go through to probate, you can always say, I have 3 children, I'm going to do paid on death to all 3. Those are just beneficiaries. They're not owners of the account. They cannot have any access to the funds while that person's living, unless one of them's name is POA. But all the bank would need at that time is a death certificate coming in, and we make a check to all 3. So that's a way that you don't have to go to probate for certain assets like that.
So I guess you talked about that beneficiary, so they can, if something should happen to you at that time, it will be no issue for them to go in and get the funds, or do they need to be put on the account as well? Like an or. So what's the difference between and or?
Okay. All right, so if mom dies and mom has 3 children and mom's wishes are at my death it all goes to 3 children equally, she can take her account. She does not have to add anyone to her account because she's got a power of attorney. So if she goes in aging process, the power of attorney has access. So she dies, power of attorney is no good. That document's no good anymore. So then the bank would look, hey, mom named 3 beneficiaries. So once we are given a certified death certificate, then we will contact those beneficiaries, and the check is a third, because there's 3 beneficiaries there. Now, when you name an account or you have an asset that says and, that means both parties have to act. Both parties have to sign, so forth. If you have it as or, either party can handle the transaction. So if I have an account with me and my mom and it's or, I can come in, because she put me on as or, the bank says, I can act, I can take all the money out, and the bank doesn't have to notify mom, okay? So if it was and, that means we would both have to agree on the transaction. But a lot of times, if the planning is right, the document's in order, you can leave the assets just in mom's name and just add the beneficiary. That avoids probate. You don't have to go through that process. But I'm telling you, it's a lot of times you will see somebody try to do such a good plan and name beneficiaries or put somebody, and then there's one stock account somewhere that they forgot about. And they're going to want the will to be probated to get access to their account. So, yes.
To get access to you, your knowledge, and the trust department at TroyBank and Trust, do you have to have an account?
No, ma'am. No, ma'am. One thing we do in the trust department, I do estate planning. I cannot draft any documents because I'm not an attorney. But we can sit down. I can give you scenarios. You can talk, because we hadn't even talked about wills. We hadn't even talked about trust. I was going to do a little bit about Medicaid planning, what you might need to do, because I know a lot of people have questions about that. So I'll give them my cards, call. I'm in Troy, but I come to Dothan for appointments all the time at we have 2 branches now in Dothan. So does anybody have, because I see I'm up, right? My time's up?
You can go for a couple more minutes, it's fine.
Anybody want me to hit on something real quick?
Medicaid.
Okay. I'm not an expert. There are attorneys that do strictly Medicaid asset protection planning. There's some here, some good ones here in Dothan. Okay, so to get on Medicaid, of course, as you probably know, your assets have to be very limited. Your income streams have to be very limited. So we have customers that we have a trust, so we have taken care of them. We've used their money to keep them at home, but when their money's gone, we've got to, what's our next plan? There's no family. So then we have to move them to a facility, a nursing home, and then we have to try to get the process of getting them on Medicaid because their money's out. So we have to, I think right now, don't hold me to this, I think it was a 60-month look-back period. So what they're asking for is they want to know what your assets are. What is your spouse's assets? What kind of transfers and transactions have you made in that 60-month time period? They're looking for you shifting assets out of to give it to the children so they can kind of hide that from Medicaid. That's perfectly fine to do that as long as you do it in that time window. Because they're going to ask right now at least 60 months, 5 years, from when you apply for Medicaid, they're going to ask for all that information. So if they see that you transferred, it's just you, your spouse is deceased, if they see that you have transferred your home to your children, and they see that within the time period, they're going to want to know what kind of value. It has to be fair market value. So you can't just give your house to your children and then run and file on Medicaid. They're going to make you sit out of Medicaid until there's a formula they'll do before they'll give you benefits. Now, some of my customers that we have to do that, they have high income, like their VA or their Social Security amount is high. Because I want to say they only want you to limit to like $2,000 is, kind of like what you can have. Now, so what happens there, they make you set up some kind of like a qualified Medicaid trust. Has anybody ever heard of that? It's a form that you print off through their system. They make you set it up. It's just a checking account that is designated that. So what happens is that the monthly benefit for the person going to the nursing home has to go into that checking account, and then it's paid out to the nursing home, and then Medicaid picks up the balance. Okay? So it's a way Medicaid is going to get all your monthly income, and then they're going to pay the remaining amount.
And what's that called?
I think it's called a qualified Medicaid trust, but it's really just you can go on the Medicaid site and there'll be a form, and they're going to tell you got to do this. It's something you don't just go do. So in the process, if they see that your husband gets $2,500 a month but he has no other assets, they're going to capture the $2,500 and then they'll pay the rest for the care. There are some rules if it's husband and wife, and the wife has to go to Medicaid. They're going to look at both assets, but there's a rule where the husband and maybe a minor or a disabled child, if they're living in the house, they're not going to force the house sale. Now, don't hold me all to this, okay? I just can get the highlights. So mom needs to go, and mom needs to have her nursing home to be paid, and here's this house that the husband's still living in. There's a formula that they'll do about the money situation, but they will not force the sale of the house as long as the spouse, a disabled child, or minor child is living there. Now, if mom dies and mom goes, it's just the husband goes, and the family hasn't sold the house yet, but all the liquid assets are gone, they'll put a lien on the house, and then when it's sold, Medicaid's going to get paid back first before the family will get it. Family farms, a lot of people, they'll try to transfer out of mom and dad, they'll transfer it to the kids. As long as you do that in the time period, you can get away with it. But the thing about that, those are some other situations you got to think about, because there's some gift tax complications about that. There's some cost basis issues when you give property while you're living to your children. Currently, you're giving them your cost basis. If you die and your will gives it to the children, they get a step-up basis in that property. So if then they went ahead and sold the house, it reduces the capital gains taxes and so forth. So their current administration is trying to do away with the step-up basis, which I think will be horrible. But so when you're trying to talk about transferring property and all this kind of stuff, you really need to sit down with someone and plan this through, because you don't want to mess up one thing by trying to do one thing, if that makes any kind of sense. And also, if you hand all your money over to your daughter, then she has a horrible medical situation. She has to file bankruptcy. You're living, you've given all your property to your daughter, so that could be wrapped up in a bankruptcy situation or a divorce situation. So a lot to think about. So, Well, go ahead.
Is the window the 5 years or is it a 7-year window that every?
It used to be 5, and I heard they were moving it to 7. It's eventually gonna get there if it's not already, because Medicaid knows what's going on. I mean, they know people are trying to move around. All right, she said it's still 5. I do see that probably increasing as they figure out what people are trying to do.
I also wanted to throw in that you mentioned the trust. We've got the Alabama Family Trust.
Okay.
There's some brochures back here if y'all want to look over like their qualifying and just contact information too, if that's something that you mentioned that. I thought that was something.
But, you know, please, if anybody wants me to come by, I don't charge for coming and visiting. People say, why do you not do that? Because sometimes once we start planning, there could be a situation where TroyBank could be needed, and I wouldn't know that, you wouldn't know that until we actually got in a room and discussed, because a lot of people don't know, a lot of people in Troy really don't know what we do in the trust department. So, any questions?
Thank you so
Oh,
much.
I'm sorry. Well, we didn't get through everything, so y'all just have to call me and I'm sorry.